Started here. I trust everybody had a good weekend, or at least a better weekend than the mayor of Cincinnati had. Rough night for him last night. We'll go ahead and get started with bill introductions. Are there any bill introductions this morning? Yes.
Okay, that's probably better. Sandy Braden Hyder and Lowe here on behalf of Landmark and One Main Financial. And would like to ask for the committee to introduce a bill on financial institutions to increase the amount on closed-end consumer loans. And the RS number is 23 RS 0504.
All righty. Any questions or objection from the committee? Seeing none, it is introduced. Thank you, Sandy.
Thank you.
Morning, Mr. Chairman. Eric Turek here from the Kansas Insurance Department. We would like to introduce RS 0699, which is the NASA or North American Securities Administrators Association model law to protect vulnerable adults from financial exploitation.
Any questions or objection from the committee? Seeing none, it is introduced. Thank you, Eric. Representative Shu.
Thank you, Mr. Chair. I have two again. The first one is RS 0691. This is a Capers COLA bill, the one where you get 5% if you're retired 18 plus years and 4% if it's 14 to 17 years. The second one is RS 0698. It's just a reintroduction of HB 2189 last year, which was the payday loan bill.
All righty. Any questions or objection from the committee? Seeing none, both those bills are introduced. Do we have any other bill introductions today? Okay, committee, I just want you guys to be aware of the upcoming deadlines we have coming up. Please take a look at your schedule. We do have a couple of deadlines for bill introductions for committee sponsorship as well as individual sponsorship. So take a look at your schedules today. If you have anything you're working on, get with me and let's try to get it introduced. All right, so we'll move on from that to our first hearing today. We have HB 2105, and we'll go with David with the reviser for an overview.
Thank you, Mr. Chairman. House Bill 2105 would add 16 new sections of law that would be known as the Kansas Earned Wage Access Services Act. Section 1 of the bill is just the name and citation of the act as the Kansas Earned Wage Access Services Act. Section 2 would provide definitions for various terms that are used throughout the act. It highlighted that earned wage access services defined in the bill to mean the business of delivering proceeds to consumers prior to the next date on which an obligor is obligated to pay salary, wages, compensation, or other income to the consumer. And then there are, of course, all the definitions of obligor and consumer in there as well for your reference. Section 3 requires a person to register with the state bank commissioner in order to engage in any earned wage access services business in the state. This section provides a list of information that would be required to be included on the application form for that registration. Applications would be accompanied by a non-refundable registration fee that would be established by rules and regulations of the commissioner. Registrations expire April 30 of each year, so it's an annual registration. And at least 30 days prior to expiration, the registration would be renewed by filing a renewal application and again paying a non-refundable fee for that renewal. Section 4 requires each applicant or registrant to file a surety bond with the bank commissioner, and there's certain requirements on how that bond should be developed, and then the bond would be in the amount of $25,000. Section 5 establishes requirements for providers that they must follow before providing consumers with those earned wage access services, and that certain disclosures that must be provided, treatment of how payments would be collected, and the consumer's right to cancel participation in the agreements at any time without incurring a charge for cancellation. Section 6 provides restrictions on what registrants and prohibits certain actions in connection with providing of wage access services. Section 7 states that a registrant providing proceeds to a consumer would not be subject to the provisions of the Uniform Consumer Credit Code in connection with those earned wage access services. The section also states that non-mandatory payments paid by a consumer in accordance with the Act would not be considered finance charges for the purposes of the Federal Truth in Lending Act. Section 8 requires each registrant to file an annual report with the Commissioner detailing their earned wage access services provided during the preceding calendar year. Information in these reports would be confidential, not subject to the Open Records Act. This section also requires the registrant to file a written report with the Commissioner within 30 days of the occurrence of certain events that impact the registrant's business. Failure to make those reports required by the section may subject those registrants to a late penalty of $100 for each day the report would be overdue. Section 9 requires registrants to maintain and preserve earned wage access services business records. If those records are located outside of Kansas, the registrant would have to provide the records within 3 days to the Commissioner or Commissioner's designee, or would have to pay reasonable necessary expenses to allow the Commissioner to travel to that out-of-state location to view the records and examine them. The registrant may provide those records electronically to the Commissioner. Section 10 establishes the criteria for which the Commissioner may deny, suspend, revoke, or refuse to renew a registration. They would need to provide notice and opportunity for a hearing in accordance with the Administrative Procedure Act before taking any of those actions. Section 11 requires the Commissioner to administer the Act and grants the Commissioner the powers and duties related to the Act, including power to adopt rules and regulations as necessary to carry out the intent and purpose of the Act. Section 12 is the enforcement mechanisms. When violations of the Act occur, the Commissioner can take action to issue cease and desist orders, could levy fines not to exceed $2,000 per incident, order restitution or disgorgement of profits arising from the violation, and then ordering person take any action in the judgment of the Commissioner that would carry out the purposes of the Act, or bar anybody from subsequently applying for registration. This also allows the Commissioner to issue emergency orders to take these actions. Section 13 establishes requirements in case of failure or refusal to obey a subpoena of the Commissioner, and allows the court to issue an order requiring the person to appear before the Commissioner and provide that those documents or testimony. Failure to obey the court order would be punishable as contempt of court. Section 14 establishes criminal penalties. When a person is convicted of intentional violation of the Act, it would have to be an intentional, knowing violation of the Act before he's subject to criminal penalty. Section 15 allows the Bank Commissioner, Attorney General, or a county or district attorney to bring an action in court to enjoin any violation of this Act or rules and regulations adopted thereunder. And then finally, Section 16 provides that all fees collected, so all those registration, renewal fees, etc., would be subject to the provisions of KSA 75-1308. And that's a statute that just requires that fees of the Bank Commissioner, the 10% be deposited in the state general fund, and the remainder is credited to the Bank Commissioner's fee fund, which is their main operational fund that they administer the agency with. The bill becomes effective upon publication of the statute book, and if there's anybody new here, that just means July 1st of the current year 2023. So anytime you see statute book, it means July 1st. And with that, Mr. Chairman, I can stand for any questions.
Thank you for that, David. Are there any questions, committee?
Thank you, Mr. Chairman. I probably missed this earlier, but was this requested by the State Banking Commission, or was it requested by private party?
The Bank Commissioner did not request this bill. It was another party.
Do you know who that was?
I believe the proponents might be able to speak to that.
Right, they're gonna, okay, thank you.
Representative Clifford.
Thank you, Mr. Chairman. David, just on page 3, line 29, about the expiration date, it seems incongruous with everything else we do in life. I get April 15th, I get June 30th, but is that just to spread the banking commissioner's workload out throughout the year, or was there some significance to that April 30th? Thank you.
Yeah, Mr. Chairman, I'm not aware there's any particular significance with that date. That was just as the bill was requested, they had that April 30th date. So I don't know if that was just to maybe spread out all the registrations, but I'm not aware of a specific reason.
Thank you. Thank you, Mr. Chairman.
Any further questions? Representative Dodson.
Thanks, Mr. Chair. Just can you give a couple of examples where this might apply? I was thinking when I first started reading this, that this is basically a mortgage lender, but I'm sure there are other things.
Yes, Mr. Chairman, Representative. I think the proponents will speak more to the specific, but yeah, this would be not necessarily a mortgage transaction, but I think it's on terms of like you have a consumer that has they've earned a certain amount of pay, and then this would allow them to enter in an arrangement to access maybe that capital faster than like the payday, so they wouldn't have to wait till they actually have the money in the bank. But I think the proponents will speak to specific examples.
Thank you.
Any further questions? I have one, David. This seems to be like regulatory framework that we're setting up here. Is there anything in current law that prohibits this business or these businesses from applying these services currently in Kansas statute?
I'm not aware of anything that would specifically prohibit this type of service. Maybe the bank commissioner would be able to speak to that if there's anything that they think is incongruent with the current banking law. But there's nothing that right now in statute that prohibits this.
Thank you, David. All right, committee, we're going to move on to our first, looks like the only proponent today is Ben LaRocco, Senior Director, Government Relations from Herndon. Welcome to the committee, Ben.
Thank you, Chairman Hoheisel, members of the committee. Appreciate it. I could take a few minutes and maybe talk about what the revisor just said, but in language that makes more sense to you. So earned wage access is essentially if you work today, you get paid today. So when we all work today, we have accrued earnings. Those earnings are legally ours, but your employer gets to keep them until payday for the purposes of payroll, because payroll is complicated, can't do it every day, so you do it every couple weeks or once a month. So there's this pool of money that folks have a legal right to, but they don't have access to. So earned wage access allows workers to access that money on their own terms. So for Earnin, we work with about 2 million consumers across America, use our services last year, about 10,000 in the state of Kansas. The way it works, like Home Depot is one of our corporate partners. You work at Home Depot today, you earn some money today, you want to get paid today, but your payday is until Friday. You can download our app, connect your bank account, and you can cash out your earnings for today's wages today. There are a number of different companies, a number of different business models. The flow of funds is pretty similar for everybody. You estimate wages, you deliver those to the consumer, and then you get paid back on payday. The mechanisms of that are a little different depending on the company, but the flow of funds is pretty similar. The first question I get always is, how do you get paid? That's definitely the first question. So there's a number of ways that companies like ours earn money, generate revenue. The first is an expedited payment, similar to if you've ever used PayPal or Venmo or Cash App. If you use an ACH transfer, it's free. But if you use debit or some other transfer, it costs money. So if you cash out your wages and you get it by ACH, that usually takes 1 to 2 business days. The transaction would be free. But if you want to have that money in your account immediately, like within 30 minutes or less, there's a fee of $1.99 to $3.99. That's how we generate most of our revenue. The second way we generate revenue is by what we call a voluntary tip. We say, hey, if you like the service, give us a couple bucks. About 60% of transactions have a tip. About 40% of transactions don't have a tip, and the average tip is $2. Some other ways that other companies generate revenue, one is on interchange, like they put the funds on a payroll card or a debit card, and then they generate funds on interchange. Another one is a subscription model. So you'd pay like $10 a month and you would get a bucket of financial services, one of them including earned wage access. And the final one is some companies who have partnerships with employers will have the service subsidized or paid for by the employer. So those are sort of the range. The ways that we don't generate revenue, there's no penalty fees, there's no interest, there's no late fees, there's no anything else. So if something goes wrong and the consumer doesn't pay us back, there's no penalties. There's no credit reporting. We don't use credit scores to determine eligibility of this, which is some of the reasons why it doesn't really fit into any of the existing regulatory buckets. And we wanted to clarify that. So maybe one other point that is relevant. This industry is pretty new. We've been around for about 9 years, which is about the time frame of the industry in general. We're one of the original companies, and we've worked with a number of states and folks over the last couple years to develop this framework. It's based on a regulatory registration rule from California, basically rewritten to do something similar in Kansas. And just to show how bipartisan this is, came from California, is also adopted by Alex. So you sort of have both ends of the political spectrum that have worked on this framework. So with that, I can pause for questions. Happy to answer anything, go deeper, answer anything that wasn't addressed. Thank you.
Questions from the committee? Representative Shu?
Thank you, Mr. Chair. Thanks for bringing this to us. I think it's an interesting idea, at least. So you said if a consumer doesn't pay you back, there's no penalties, late fees, interest. How do you guys recoup that?
Yeah, so basically the only recourse we have is we deny them access to the service in the future. So if you don't pay us back, you can't cash out your wages again in the future, but that's it. So we just understand that there's going to be a certain amount of risk loss in that. It's fairly low. But putting it in perspective, we've done about 200 million transactions over the course of our business. So when you've done that many transactions, you sort of understand the law of large numbers and averages, and you just build that into your risk model.
Representative Smith?
Thank you, Mr. Chair. Thanks for being here. Now, you're saying if they want their money that day, they can get that money.
Correct.
You know, I kind of live that life myself. I always needed money because I made a marginal income. But if I did that at the end of the month, I'd really be hurting because I couldn't pay my mortgage. I couldn't pay my car. I just think it's asking for bigger problems.
Well, so we like to ensure, so you can access a maximum of $100 per day or about 80% of your take home pay. And I think one thing that's important is that when you are waiting till the end of the month, you end up having a lot of bills piled up and wait to the end of the month. You get that big chunk of change and then you pay everything. That often will include late fees, maybe overdraft fees from your bank because things went through early. If you can access your pay early, a lot of those bills that previously waited till the end of the month, you can pay those in real time. As the bills come in, you can pay them. Now, people can, of course, get in trouble with this, just like they can get in trouble with any other financial services if it's not used properly. But we think giving people access to the money that they've earned on their terms is the right thing to do.
Again, I think it's a good idea, but I just think it leads to bigger problems. Say the guy goes to the casino. It just can lead to bigger problems, I think. But thank you very much.
Appreciate that.
Chair.
Thank you.
Representative Shu?
Thank you, Mr. Chair. And this is just kind of piggyback on Representative Smith's concerns, which I think are fair, but I guess I can also see an alternate universe where this is used in lieu of payday loans, for example. Do you guys see evidence of that in the states that you're in?
Yeah, we absolutely. We ask, we ask our customers, why do you use this service? What do you use it for? The number one answer is an alternative to bank overdrafts. So they can use this so they don't have bank overdrafts. Payday loans, late fees on bills, late fees on rent. Late fees on rent end up being a form of soft credit in a lot of ways. Rent's due on the first. You don't get paid till the 5th. You're willing to take that $10 a day late fee to pay some other bills. Also, one thing that's interesting that we've heard from our clients or from our customers, and we've seen in the data, in the account data, is that people end up having higher earnings. And we ask people why that is. They're able to, they don't have to miss a shift because they haven't been able to fill up their tank, or they're able to, like, when, something that would be a small problem to a lot of folks ends up being a big problem to some folks who have liquidity crunch. And so having earning allows them to weather that liquidity crunch, get to work, pay that bill before it spirals out of control.
Representative Clifford?
Thank you, Mr. Chairman. My son actually had a pay card from Home Depot. Now that's where his pay went. But once he resigned, we're having difficulty getting that back because it seems like it was subject to Dodd-Frank registration requirements because of underlying concerns. And I mean, we've been talking to the Philippines for 2 months, trying to sort out sending his social security number, driver's license. So when someone signs up with you, how much of a hurdle is it?
Yeah, so I would say it's a much different situation with us. We don't require. We do, of course, comply with know your customer laws and anti-money laundering laws and all of those federal financial statutes. However, we don't require driver's license. We don't require a social security number. So folks who are new to this country or don't have credit or other things can access it. But the thing, we extend the funds and then get paid back. So at no point are we taking control of customers' funds, or if there's an error, we've already extended the funds and getting it back. So a situation where your son would be owed some money and not getting it wouldn't occur with our particular service, especially with Home Depot.
Thank you, Mr. LaRocco. Thank you, Mr. Chairman.
Representative Schmiley.
Thank you, Chairman. Okay, so you mentioned that they can access 80%. Is that because of incidentals that come out of your check, taxes and things like that? Or are they going to be on the hook for paying taxes at the end of the year?
Sure. Yeah. So ours is net. So it is based on take home pay. So if you made $150 gross and you took home $120 net, then you would be able to access like $100 per day. So for ours, it is totally after paycheck. So all of your normal tax and payroll deductions would be completely untouched by our service. Other services are a little different, but I think generally all of them are going to estimate that take home pay so that no workers will run into that situation.
Okay, and one other question. Is there a cap on the amount that you can take out? Not the percent, but is there like a monetary?
Yeah.
You can't take out more than 2,000?
Yeah, exactly. So I would say every company has a little bit of a different risk model, and some are lower, some are higher. Ours is $750 per pay period with our base service. So $100 per day, $750 per pay period. We have a premium product that is $1,000 per pay period. But those are the general numbers.
Okay, thank you.
You're welcome.
Representative Mon.
Thank you, Mr. Chairman. So how does this work as far as you're hooked in with the employer's payroll system, right? So when the employee says, please, can I get some of my money? You just tap into the employer's payroll system and the money goes to you and then you distribute it, or does this get distributed straight from the employer?
Sure. So there's a number of different business models. I think you might hear later from one of the other business models that is integrated in the payroll system. We are not. We use different methods to estimate pay. So you connect your bank account using a service called Plaid. It's an API that allows us to see, hey, you've gotten paid $1,000 every other Friday for the last 6 weeks. So we know on average you make this much. There's other things built into our app that allow us to estimate the amount of money you've made. Then we have a line of credit. We extend our estimate based on that line of credit and then get paid back on payday. The employer is not directly involved in the flow of funds for us. Again, that is a little different than some other companies where they might be and they might get paid back in a different way.
Thank you. And so when you indicated that you make most of your money through the debit card fee or the instant funding fees.
Correct.
Is this instant funding to their debit card, or do you give them a kind of a
correct? No. So let me phrase. So generally, it is they have an account at Bank of America or their credit union or whatever. They connect that account, and then the money is available in that account. Some companies do offer a bank account or a debit card that's connected to their bank account. Ours is a pass-through. There are going to be other products that have a slightly different flavor on that, but in generally, anybody can connect to their own account.
So yours is directly to their debit account or debit card on their bank account, but some companies will issue a virtual debit card of some sort.
Correct, and that's going to be the consumer's choice, right? The consumer is going to be able to opt into whatever service they prefer.
Thanks.
Representative Smith.
Thank you, Mr. Chair. Thank you. A few things, but I feel like I'm an expert at this, so because I lived it. my credit union, and I'm sure the bank does the same thing, I spent more money every month than I made. And I only got paid once a month, so we had to live very frugal. But the credit union had an expanded check where if I went over, they would accept my checks. And at the end of the month, I had to pay that loan. I'm sure banks do the same thing. And that was the first thing I paid off. So I didn't pay. So it was really pennies. I didn't pay very much because I paid it off immediately. And I just think we're opening. Some people are not fiscally disciplined, and I just think they're going to really get in trouble by doing this. So that's just my opinion for somebody that lived it. So thank you very much.
Thank you.
Thank you, Mr. Chair.
Representative Williams.
Thank you, Mr. Chair. I just have one quick question. How many states have enacted the Earned Wage Access or Service Act in that?
So California has put this forward, a very similar framework as a proposed rule via regulation from it's called the Department of Financial Protection Innovations, their version of OSBC. We supported that framework. They put it out about 14 months ago or so. And so we took that framework and adopted this bill to a number of states. It's been introduced, I think, so far in 5 states this year. But as we're still early in the session, no states have approved it.
Okay, thank you, Mr. Chair.
Representative Poskin.
Thank you, Mr. Chair. 2 questions, if I may. The first one is repayment. Is that through an automatic withdrawal from the person's bank account on a set day?
Correct. So there's a number of different repayment options. The first one would be a normal ACH transaction, which is the same way you would pay your phone bill or utility bill or whatever. And that is going to come out on your payday. So we analyze your payday. If for some reason we get it wrong, we have 24/7 customer service. You contact them. You say, no, I'm not getting paid this Friday because it's a holiday. I get paid Monday or I get paid Thursday. And you can change that. The second way we get paid is we offer you a bank account that's a pass-through account. So going back to that question. So basically, your direct deposit would go into an account. We would take the funds that we advanced you, and then we would pass that money through to your normal financial institution. Other companies do it differently. They might debit your paycheck in the same way that you would have insurance withheld from your paycheck, or they provide it differently. So I think one of the other folks testifying today might be able to talk about that as well. But there's a number of different options depending on the company and the business model.
Thank you. And then my follow-up might be a little more complex, but it states in your testimony that this is not a loan. And I would like you to maybe expand on that
Sure.
and help us understand how it
Sure,
is.
yeah. So generally the legal definition of a loan is going to have 2 things. One is a legal right to repayment, and there's no legal right to repayment for these transactions. So again, if you don't pay us back, we have no legal right to repayment. We can't send you to collections. We can't sue you for non-payment. We can't report you to a credit bureau. So that's sort of one of the first differentiators. The second one is that there's no mandatory fees. So generally, a loan is going to be for a fee. You have interest, you have origination fees, something like that. These are the base service requirement for this is that there's no fee. So all of the companies that currently offer this have at least one option that's free, and that's a part of the bill that you have to have at least one free option. So those are the main legal definitions. Sure.
Representative Dodson.
Thanks, Mr. Chair. Just one quick question on this, as I understand it, establishes a framework for those businesses that opt to participate rather than a mandate for all business to participate. Is that correct?
To be honest, I don't actually know that. It might be better for him.
For the revisor.
Thank you, Mr. Chairman. Yeah, under the bill, I mean, this does establish the framework for these particular services and allows for people to register with the bank commissioner, but it doesn't mandate that businesses or anybody will do this. It would just be that would be a sort of a contractual arrangement if they wanted to. And then they would have to follow these provisions.
Thank you. I just wanted to check because for a big company like Home Depot, the software and all of that stuff is pretty easy for them. But for somebody downtown on Main Street, it might not be so easy.
Yeah, just to be clear, Home Depot would not have to register. It would only be companies like Earnin who provide the service that have to register. And our service is available to any employee at any company, big or small.
I have one question. I'm sorry. Oh, Representative Monk, go ahead, sir.
So I understand that the proposed bill says that this is not a loan. What's how does CFPB, the federal government, view this? And are we going to be in a situation where we go through the trouble of setting this up and suddenly the feds say, "Hey, look, this is a loan," and change?
Absolutely. So, so in 2017, the federal government released I forget the exact term, but it's basically a short-term payday loan act. In that act, it basically said if you do these things, and those things are basically saying non-recourse, you can't sue anybody, you can't send anybody to collections, you don't have any mandatory fees, you don't charge interest, then you are not subject to the payday loan rule, you are something else. And so that was really the first government differentiation of basically what is a loan, what is earned wage access. And from there, it sort of built into other things. And then, federal government said that in 2017. State of California first acted in 2021. And so this is like the progression on that.
And so my understanding is that 2017 rule is still in limbo, right?
It is now in limbo, correct? Yes.
In litigation, and so hasn't actually been mandated.
Correct.
But I think the CFPB has spoken directly about whether earned wage access is a loan or not.
Yeah.
Can you speak to that?
Yeah, they have. So they did that. They also provided another advisory opinion in 2020 where they said that earned wage access subject to a few criteria is not credit under the Truth in Lending Act. Sure.
So are you or any other business offering these services currently in Kansas?
Yes, we are. Yeah, we have about 10,000 Kansas users in 2022. We had about 10,000 users. And to my understanding, most of the companies that are providing the service probably have some consumers in the state of Kansas.
And at least in the opinion of Earned In, you guys are, as of right now, operating within the law.
Yes, we believe so.
So this would just establish regulations on your current business.
Correct. So this would clarify, what we are and would not exempt us from any current law.
Committee, any further questions? Seeing none, thank you so much, sir.
Thank you so much. Appreciate it.
All righty, we have no other proponents listed. Is there anybody else that would like to speak from the public on this? Seeing none, we will move to. Oh, I'm sorry.
No worries. Hi, I'm Ryan Naples. I am the senior.
Yeah, Ryan, we have you listed as an opponent.
Oh,
so
yes.
Yep.
A little bit in between, but okay.
Yeah, you're fine. We're going to work our way down and we'll get to you shortly, sir. Thank you.
All good.
Yep. Up next, we move on to our neutrals. We have Molly Jones, VP of Government Affairs for PayActive. Molly, are you with us online? We don't have Molly. Okay, we will move Molly. I believe we have her testimony. We will move that to written. We will move on to Steve Schiffelben. I apologize, sir, if I butchered that last name. Kansans for Payday Loan Reform. Steve, welcome to committee.
Well, thank you very much, Mr. Chairman and members of the committee. Good morning. My name is Steve Schiffelbein. I am here on behalf of a broad bipartisan coalition called Kansans for Payday Loan Reform. A few key members include Topeka Jump, KIFA, the Kansas Catholic Conference, and the AFL-CIO. The main objective of the coalition is to win legislation that will put more protections in place for borrowers who choose to use payday loans in Kansas. We are here today to provide neutral testimony for House Bill 2105. The coalition was pleased to hear that this committee is taking up matters related to small dollar loans. We only learned about this bill last week, so we have not had a chance to adequately review the bill, which is why we are not providing a more definitive testimony as proponents. But we thought it would be important to be here today and to communicate that this is a very important matter. Thank you to those of you who have done the work on this bill. As our coalition is learning more about the legislation, there are a few questions that we hope members of the committee will consider. What borrowers is this bill most likely to impact? We should be careful to ensure that the steps taken to minimize predatory lending in the state of Kansas include the most vulnerable, like our veterans, people with disabilities, and seniors. Many of the folks that fall into those categories do not have employers that are going to be able to provide a safe, small dollar option like the ones mentioned in this legislation. Another question to consider, whether this bill passes or not, is it okay for payday loan companies to still be allowed to do harm by charging exorbitant interest? We urge this committee to do the work on these bills, but also to do the work on the actual payday loan product itself so that we can create a healthier economy for Kansans. There are not enough consumer protections on payday loans, and we hope to talk about this more in this committee in the future. Thank you again for the work that you're doing on this bill to create opportunities for people who need help. Thank you.
Thank you, sir. Do we have any questions for Mr. Schiffelbein? Seeing none, thank you so much, sir. Is anybody else from the public want to speak as a neutral to this legislation? Seeing none, we will, okay. Ms. Jones, are you online with us?
Yes, I am. Sorry, I missed that
Okay.
earlier.
No, you're fine. Go ahead, ma'am.
So good evening, or sorry, good morning, and thank you so much for taking the time to have this public testimony today. My name's Molly Jones, and I'm the Vice President for Government Affairs at a company called PayActive. PayActive is an earned wage access provider, and the way that our model works is that we partner with employers to enable their employees to access their earned wages on demand when they need it, rather than waiting 2 weeks to a month for payday. As you can imagine, this is a critical lifeline for many workers who need short-term access to liquidity and enables them to avoid taking out a payday loan or other predatory loan. PayActive was founded in 2012 as the first EWA provider, and we've grown to be one of the largest providers in the space today. We partner with over 200 employers in Kansas, including many small businesses, and have served nearly 30,000 Kansas workers. We have appreciated your leadership and work on this important issue and support efforts to create important consumer protections for EWA providers in Kansas, though we are admittedly new to this bill as we've only seen it just recently. As you may be aware, this would be the first earned wage access bill to pass in any state, and as such, it's important that the bill address the breadth of the industry. Along these lines, we believe that it's essential that the bill differentiate between the employer integrated earned wage access model and the direct-to-consumer advanced model. Fundamentally, these models operate very differently. One partners with an employer via a contract and integrates into their payroll system to verify wages and do not use tips, and the other markets directly to consumers without verifying wages through an employer's time and attendance payroll system. Given the differences in how these models operate, it's important to have consumer protections that are appropriate for each model. Third-party experts like the Financial Health Network and many other groups make this distinction, and we believe it's important that we do the same in Kansas. I've also submitted this testimony in writing, and I'm happy to take any questions. Thank you.
Questions from the committee? Representative Ma?
Thank you, ma'am. Could you please kind of give us a little bit more information about the difference between those two models as to how they work as far as accessing the payroll provider in an employer and then versus sending the money directly to the consumer? The follow-up question would be also, actually, I'll just let you answer that initial question, and then I may have a follow-up after that.
Okay, great. So the way that the employer integrated model works is that we contract directly with an employer. say Wendy's is one of our employer partners. We sign a contract with them, and then they make pay active services available to their employees to sign up. It's optional. If I am a Wendy's employee, I will go in, I will download the Pay Active app. I will use my employee number to log in, and that will then connect me with whatever payroll system Wendy's uses. At the end of each shift, I can see how much money I have earned in the app based on that time and attendance payroll data. And then I will go, I can access up to 50%. We cap that at 50% of those earnings in advance. And then come payday, that is kind of a wage adjustment from their paycheck, is that money is taken out. So that's, at a high level, the way that the employer model works. I can't speak directly to the direct-to-consumer model, but as I understand it, they look at past pay stubs to use that as an estimation of future earnings. Other providers use geolocation data to determine when and if you're at a place of work and use that to estimate your wages. But the distinction is that it's the consumer's representation of their own wages rather than verified through a payroll system.
And so obviously your system where it's direct from the employer works very well with a large employer where you can just tap into through an API to their payroll system. How does it work with a smaller employer? So somebody who maybe has 10 or 20 employees and wants to use this model, is there a way that works?
Yeah, that's a great question, and an important question. We work with many small businesses, including in Kansas. They do need to have a time and attendance payroll system. There's a couple of different ways we have that works, but generally we do have a number of small businesses that use our service.
Representative Shu.
Thank you, Mr. Chair. Thanks for your testimony. Have you introduced language here or in other states that does differentiate?
We have, yeah. We've introduced bills in New York, New Jersey. There's an active bill in Nevada this session. We fundamentally weren't aware of this bill, so apologies we haven't provided alternate language. But we'd be happy to share amendments to the bill if that would be helpful.
Ms. Jones, I have one question for you. Do you guys currently offer services in Kansas?
Yes, we do.
Roughly how many customers do you guys have in Kansas currently?
So we partner with employers, and we have about 200 employer partnerships in Kansas. We have about 7,000 users active on the app, and to date, we've served about 30,000 employees in Kansas.
And while this specific legislation may not cover you guys, would, if this became law, affect you guys in any way from still offering those services in the future?
So I believe that we would be covered by this bill, and we would be required to register in the same way. However, we believe that it's important that there's a distinction between the type of provider that is operating.
Okay. All righty. Seeing no further questions. Thank you so much, Ms. Jones.
Thank you. Appreciate it.
All right, committee, we'll move on. We have one neutral written from Brock Ryler from the General Counsel of the OSBC. I do want to point out in his testimony, he does have some proposed changes, a balloon amendment. And from what I understand, the proponents of the bill and the OSBC have worked out this amendment, and I believe are all good to go on all fronts of this. So I did want to point out to you that if and when we do work this bill, we will have the amendment that the OSBC is proposing. We'll go ahead and move on to the opponent section. Now we have Ryan Naples, Senior Manager of Public Policy for Daily Pay Incorporated. Ryan, welcome to committee.
Thank you all so much. So good morning. I am Ryan Naples. I'm the Senior Public Policy Manager at Daily Pay, and we're an earned wage access provider that integrates directly with businesses similar to the company you just heard from, PayActive. The earned wage access industry is new, and businesses are all a little bit different. But the one thing that that we do share is that we all provide a low cost or no cost access to the wages people have already learned. Daily Pay does operate by integrating directly with an employer's time and attendance data and using that to verify an employee's wages during the pay period that a person is seeking to access their earned but not yet paid income. We work with some of the largest retail, grocery, and hotel chains in the nation in order to provide their employees this service, such as Target, Kroger's, Hilton, and McDonald's. We are the largest earned wage access provider in the country, and last month, 1.2 million customers from over 800 businesses made a transaction on our platform in all 50 states, including in Kansas. Of critical importance to the core mission of Daily Pay, our product, which is either no cost or for a nominal ATM-like fee, has been proven to replace much more costly financial alternatives like overdraft fees, payday loans, paying a bill late and receiving a penalty fee and interest that lead to really a never-ending cycle of debt. We've done research, really we do research every year essentially to ask our users what they are using it for. And it is almost always to pay a bill to prevent getting a late fee is the number one. Number two is nearly 100% replacing usage of a payday loan. And number three is also nearly 97% of people don't overdraft their bank account once they have access to Daily Pay. And rather than actually making them less financially responsible with their pay, our data has shown 2 years in a row, and we're doing a third study again this year, that it makes people more responsible with their actual pay because they're able to pay their childcare costs on time, their utility bills on time. So today, I do appreciate the opportunity to join you all via Zoom and regret to not be testifying in person. At Daily Pay, we do welcome this conversation and are committed to finding a legislative path forward for this session that provides regulatory certainty and oversight for financial technology companies like ours, as well as protection for consumers. We believe it is possible to properly license all companies in the space while simultaneously balancing consumer protections and consumer choice. For employers, we're an attractive benefit. Earned wage access helps reduce turnover by up to 70% in the nursing home and home healthcare industry and help all business owners offering Daily Pay to fill jobs, open jobs, 52% faster. Plus, 59% of employees using Daily Pay say it makes them more motivated to go to work, resulting in reduced absenteeism, something that Ben LaRocco mentioned earlier. These mutual benefits we bring to both employers and employees are important to the mission of our company, and it's why the earned wage access industry is growing so rapidly. However, we would like the committee to consider that not all companies and earned wage access products are alike, and we urge that this be reflected in the legislation that is currently under consideration today. If Kansas does choose to pass HB 2105, this will be the first state in the country to pass an earned wage access law, as Molly alluded to earlier. For this reason, we do hope that we can be a resource in contributing to amending the law for the purposes of drafting it with the entirety of the industry considered. As presently written, the current bill primarily is drafted to fit an earned wage access company that is structured very differently than ours. It is designed to license companies that do not integrate with employers and work seamlessly through payroll like we do and others, but instead advances funds to workers based on their own representations via bank account access, geo-tracking location, and other assumptions about wages. In addition, the bill is designed to license companies that collect repayment largely by automatic debiting workers' bank accounts, again, as everyone has already alluded to, but this model is quite different from the employer integrated structure we deploy, and we hope we can help revise the legislation in the coming weeks to account for these fundamental changes. Specifically, we recommend a few changes. They include tweaking the definition of licensing criteria, adding necessary statutory language to address the differences in our structure, and adding clear disclosure requirements for fees for all earned wage access consumers. We do support the legislature's interest in licensing the earned wage access industry this session, and we are grateful for the opportunity to speak with you today and provide this testimony. We do look forward to working with you all on this legislation together with the bill sponsor, our partners in industry, and with everyone on this committee and the rest of your colleagues in the legislature. So thank you for your time this morning, and I look forward to helping with or answering any questions.
Committee, any questions? Seeing none. Ryan, I have one. Are you currently operating in the state of Kansas?
We are, yes.
Okay. And if this, I know it covers some of what your company does, but if this were to pass, would it have any impact on your company? Or would you still be able to provide those services?
So we would have to see what the devil would definitely be in the details, as they say. We'd have to see what the language, how the language actually comes out, like how the bill is actually written in the end. I mean, the very first line, for instance, is something that our company doesn't do, right? No employee ever represents their income to us. So it's like that would be incongruous with our structure. So we partner with ADP. So we partner with large employers, but also really we partner with ADP, the payroll company, and we partner with banks too, so they can offer our service seamlessly to their clients. And so the question is, how much do we have to restructure those partnerships based on the way this law is written because of the different ways that, like the different language used and those different requirements. So it's a little bit like refining the language would I think definitely be necessary. I don't think there would be zero impact is really why we had to make our position like oppose unless amended.
Okay. And if this doesn't pass, you will still offer these services in the state of Kansas, correct?
Correct. I mean, I do think there's a good reason to be having this conversation, which the proponent of the bill did mention at the beginning of this hearing. So we definitely think it is a good idea. But yes, that is true.
Okay. Any further questions from the committee? Representative White.
Thank you, Mr. Chair. I'd first like to commend all you companies for stepping up and saying we need to be regulated. I don't quite know I understand how that jives with me, but if these different companies would get together and amend the bills and talk it out and then bring us something, we would like that. And the fees would cover the extra bank examiner, if you will. That would be very commendable also. I guess I really don't have a question.
Right, and I should say, we're speaking for like the three biggest companies in the industry who happen to have people who do this full time. This is a very new, innovative space, and so there are other smaller companies who have general counsels. We work closely with a company that similar to ours that only works with small businesses of people who employ, I think, like under 20 employees. So there's a lot of, I think there's, a path forward, but there's a lot of other voices for sure, besides the three of ours.
Thank you, Mr. Chair.
Any further questions from the committee? Representative Williams.
Okay, so maybe you could just provide a circumstance where this framework would be needed if you're able, all three, to operate and do business here in the state of Kansas and provide these opportunities. I understand the consumer protection standpoint, but what circumstance would there be that there would be the good of the framework? I don't know who should answer that one, if that would be an opponent or a proponent or neutral.
Maybe the proponent wants to answer that one. Ben, all you.
Sure, happy to talk about that. And I'll say we definitely are having conversations to see if we can accommodate the other two folks who have spoken today. We're talking a number of states, and we worked for a year and a half talking with many stakeholders, and apparently there's still a little refinement. We're hoping we can get there soon in the next couple of days. Most financial services are regulated. When new technologies come up like ours, they don't always fit into existing regulatory buckets. So the reason for advancing this legislation is to create a regulatory bucket that makes sense for this technology, not trying to force it into an existing technology. So we're not trying to exempt ourselves from anything, as I've said before, just trying to create a regulatory framework that works for the product as offered, that protects consumers and allows us to grow and invest.
Representative Mon.
If I could follow up on that, would this regulation prevent other companies from entering into the space?
To my knowledge, this would not prevent anybody. The only barrier that I could see is that they would have to register, but it doesn't change anybody's business model to the best of our understanding. And if it did, we'd be happy to accommodate.
All righty, seeing no further questions.
And
thank you,
and
Ryan.
I would add, I think we probably want to. We probably do want to leave some time to hear from some of the smaller ones that are, who we can't speak for, because like as Ben alluded to, like we're all like working together in other states, because they can speak to some of their concerns around, there's one thing about whether or not you can be licensed and whether or not you're licensed, and there's another thing about like the cost of compliance when you're running like a business day to day that's innovative and offering an important service like this.
All righty, thank you so much, Ryan, and I do thank you all for joining us via WebEx today. With that, committee, we'll go ahead and close the hearing on HB 2105. We will move on to open the hearing on HB 2133. And Revisor David, if you'll give us an overview.
Thank you, Mr. Chairman. House Bill 2133. This bill repeals KSA 16A-2-403 and the UCCC, the Uniform Consumer Credit Code. This is the statute that prohibits the imposition of a surcharge on credit card or debit card payments. So that's sort of the real peanut of the bill. The actual statutes being amended in here are previous exemptions to that surcharge prohibition for cities, counties, school districts, colleges, etc. And since that statute's being repealed and eliminated, we no longer need to have those references to the statute in here and have those exemptions. So that's just clean up within these various different statutes to reflect the fact that the surcharge is being repealed. So there's no need for an exemption to the surcharge. This is another bill that becomes effective on publication of the statute book July 1st, 2023. And I'm happy to stand for any questions.
Questions from the committee? Representative Chu.
Thank you, Mr. Chair. I was comparing this to the bill that was introduced last year, and I noticed that there was just some additional stricken language in subsection E of section 4. That's basically just we passed legislation last year or in the last term that got added onto this section, and so we're just striking additional language, right?
Yes, Mr. Chairman, I believe that's correct. It's just that statute had been amended back in last session, but yeah, this is just this language will no longer be needed because we're repealing the surcharge statute, so it just drops off. Yep.
Representative Mon.
And it's kind of the same line. I just wanted to clarify that KSA 16A-2-403 is being repealed because the federal court found it unconstitutional, and it's just being repealed in its entirety.
Yeah, Mr. Chairman. Yeah, the request is just simply to repeal it. I don't know if I can reach into I can't really speak to the why we're doing this. I think there may be proponents that can speak to that. But I would also point out, on my apologies, the back of the bill brief, the memo has the statutory language. If you would just for your reference, if you want to look at see what it says now. But yeah,
sure.
If I could follow up on that, was there a court case that did strike down this? I guess the credit card surcharge fee.
There's not a Kansas court case to that effect, but there has been some in some federal court of appeals. And I think it actually went up to the Supreme Court and was remanded back down for some consideration. I think it was in New York and some other states, California perhaps as well, that said these similar types of state prohibitions on surcharges are unconstitutional under the First Amendment. But yeah,
Representative Mon.
And just addressing your question, Mr. Chairman, CardX versus Derek Schmidt, 522 FSUP, 3rd 929 2021 district court case, federal district court case. found it didn't go. That case itself didn't go up on appeal. They did. The district court did find that statute was unconstitutional. So to respond to your question, but I did want to follow up on. So has the statute been repealed last session, or is it up for appeal this session? Is that?
Yeah, the statute has not been repealed. That's what the bill would repeal it effective July 1st. So that's the policy under consideration in the bill. Yeah.
Yeah, Representative, I believe we did pass this legislation out of the House last year. I think it went to the Senate and then died over there. So that's why we're taking another bite at the apple this year.
Thank you, sir.
Representative Dotson.
Yeah, my memory was that at least for municipalities, we allowed them to pass along the surcharge. I know in Manhattan on the water bill, we get a lot of complaints because if you pay your bill online, not only do you pay your bill, but you have a surcharge for use of your credit card. So this, as I understand what was just discussed, this would eliminate that surcharge.
Mr. Chairman, this would not eliminate the surcharge. It would actually allow for any merchant or entity to impose a surcharge, because right now there's a specific exemption. If you look at this for the city specifically, it is on page 1 of the bill, lines 16 through 18. The language that's being stricken out was actually currently under law is an exemption to allow cities to put that surcharge on. And then, so if the statute's repealed, the surcharge prohibition goes away, they would still be able to put the surcharge in, and then not only these specific exemptions, but then it would just be generally any merchant or could do so.
Thank you. Appreciate that.
Seeing no further questions, thank you so much, David. All right, we will move on to our first proponent today, Eric Stafford, VP of Government Affairs, Kansas Chamber.
Mr. Chairman, I'm sure you're very happy today.
It was a good night. It was a good night.
As a Colts fan, I'll just reiterate, and so you all don't take for granted how important it is to have a good quarterback. And you guys have the best in the league, but I also think those were the two best teams in the league playing last night. So congratulations. Good morning. My name is Eric Stafford with the Kansas Chamber, here to testify in support of House Bill 2133. To answer a couple questions, yes, this bill was passed last session by the House, but not by the Senate. And few reasons for that kind of got hung up at the end through conference committee reports and all that kind of stuff. But under the umbrella of the Kansas Chamber, we have the Kansas Retail Council, where we're the state affiliate for the National Retail Federation and pursue policies that help the retail industry. That council is made up. We have restaurants, we have larger retailers, but predominantly small independent Kansas retailers make up the membership of that organization. So this is an issue that has been taken care of by the U.S. Supreme Court. The Cardex decision that was just mentioned on a district court level here within the state of Kansas as well for restrictions of free speech. Essentially, this is a cleanup in our view of taking a statute off the books that's no longer really enforceable. The Attorney General of Oklahoma is also one of the 4 states that has some sort of prohibition of passing credit card fees on, along with Kansas. After that U.S. Supreme Court decision, the Oklahoma AG said, yeah, our statute's pretty much unenforceable. Our previous Attorney General said the same thing, although no formal opinion, to my knowledge, was issued on that. So you'll hear some testimony coming up later from some credit card companies. This is kind of really the big hang up for us right now. They're wanting to place in statute a requirement on businesses that they post notice to their consumers that they're going to pass those credit card fees on to the customers. So we've been trying to get input from our folks, working with my brother from another mother, George Stafford, to see if there's any common ground that we can find with the credit card companies. And the response that we have gotten just continues to be no. From our retailer perspective, our larger retailers have said, we're not passing credit card fees on at this time, so it's a non-issue whether there's a disclosure or not. Our smaller retailers are the ones that kind of have the reluctance where they feel like it's just not government's role to get involved in what fees we pass on or what surcharges we have, and doesn't necessarily need to be regulated. Additionally, in our testimony, you'll see I've highlighted provision on page 2 that is from the Visa contract arrangement with retailers and merchants under their Q&A section on whether merchants can pass along credit card fees. In that question and answer piece, in the contract with Visa, merchants and retailers have to disclose today under that contract if they want to provide that Visa service with their customers. They have to disclose those credit card fees being passed on to their consumers. So it's already a contract provision. It doesn't need to be statutory in our members' viewpoint. So our request would be to avoid any mandates on businesses that, in our view, are not necessary. So I think those are the points that we'd like to make. I'm glad the representative brought up the CardX case. That's one Scott Schneider actually has sent out to our retail group and made them aware of. But happy to answer any questions at the appropriate time, and would appreciate your support for House Bill 2133.
Questions from the committee?
Representative Schiff. Thank you, Mr. Chair. Thanks for being here. I guess I just want to ask from a broad level, can this or will this increase prices for our constituents?
Not necessarily. I mean, if they choose to pass on the credit card charge, then yes. But there are some retailers that are doing that today that you visit, but there are inflationary fees that people are passing on. There are fees associated with Ticketmaster. You saw the Taylor Swift debacle a couple months ago, and now there are congressional hearings over Ticketmaster. And I think that's the point from our retailers' perspective is government's not regulating the fact that Ticketmaster says our ticket price is $100, but then when you pay, it's $132.45. So there are already fees being passed on. Is it increasing the cost of goods? No, it's passing on those charges if you're choosing to utilize a credit card or use a credit card. So you can pay cash and not have an increased cost, but it is already happening because of those court decisions. So I don't think this would have any impact on your customers or your constituents outside of what factors have already taken place. Passing this bill would be no different than it's just cleaning up statute in our view.
Thank you. Thank you for that answer. If you thought, I don't know about that example because Taylor Swift tickets were significantly more than $132.40.
I wasn't buying them. Yeah, fair point, Representative. So yeah.
Representative Mon.
Thank you, Mr. Chairman, and thank you for being here. So does this also open the door for retailers to provide cash discounts? Because there was this weird sort of thing where a cash discount was being interpreted that you were actually doing a surcharge for folks with credit cards. So could this actually allow for prices to be lowered for cash customers?
I think it could. I think you see that with some gas stations today. If you pay cash, they have two advertised prices, cash versus credit. So yeah, I think it does definitely, I think it clarifies, again, it's clarifying that they have that ability today, or they would have that ability if we're to pass.
Representative Shmuley.
Thank you, Chairman. Just to clarify the wording, we keep talking about credit cards. Will this also apply to debit cards, gift cards, things like that, anytime you run a card of any kind?
I think there's a difference. If I remember, again, looking through the Visa customer or merchant agreement in the Q&A, I think there was a discrepancy, and Scott might be able to back me up on this when he speaks. I think there's a difference between debit cards and credit cards on whether they can or cannot pass certain fees on. I might defer to Scott because I know that this is something that he's also dug into heavily. But if we don't have that answer, we'll figure that out for you.
Thank you.
Any further questions? Seeing none, thank you so much, Eric.
Thank you.
We're going to move on to Kevin Gregg, Associate Executive Director for Fuel True. Kevin, welcome to the committee.
Thank you, Mr. Chairman, members of the committee. I am Kevin Gregg, and I represent Fuel True, which is previously known as the Petroleum Marketers and Convenience Store Association of Kansas. We represent both small and large retailers throughout the state, and credit card transactions are a significant portion of the money we collect on sales. To put a dollar amount on what the credit card fees represent to our business, we surveyed some of our board members. One of our retailers who has 4 stores in the western part of the state, in 2021, these 4 locations had a total net income of $274,000. The credit card fees for those businesses totaled $243,000, almost the entirety of the net income for their entire operation. We have a larger retailer with 24 locations across the state, and in 2021, they paid $2.4 million in credit card fees, almost 40% of their net income. In addition to the fees we already pay to credit card companies, we're also required to comply with anti-fraud technology on our fuel dispensers at our stores. We're not necessarily required by the credit card company, but if we don't comply with the chip card technology to reduce anti-fraud, we're responsible for gas station drive-offs. And in this particular case, we have a member in North Central Kansas who has 10 locations, and they have upgraded 7 of those 10 locations to the chip card technology on their fuel dispensers. The cost of that compliance was $420,000. And at the 2 non-compliant sites, he had $21,000 worth of fraud cases that the drive-offs in a single year, which he had to pay for because he hadn't upgraded those pumps. He's working quickly to upgrade the other sites. And the remaining location he purchased, it was a new location. He purchased brand new pumps, and they were they were equipped with the new technology. Credit card fees are essential to our business, or accepting credit card fees are essential to our business. No matter the size of our retailers or the number of our locations, each one of our members bears the cost of credit card fees and compliance. As cities, counties, and other government entities were allowed to do with the existing legislation, we ask that our retailers be granted the same courtesy. We ask for your support on House Bill 2133, and I'll be glad to answer any questions.
Questions from the committee? Seeing none, thank you so much, Kevin. Up next, we have Scott Schneider, attorney for the Kansas Restaurant and Hospital Association. Scott, welcome to the committee, sir.
Thank you, Mr. Chair, members of the committee. I'm Scott Schneider on behalf of the Kansas Restaurant and Hospitality Association. This is one of the more interesting bills that I've run across in a while because of its legal history and the many challenges that this has been through. Representative, you're correct. The Cardax case was decided recently in the federal district court, and it was decided on free speech grounds. And so as we think of this as a surcharge bill, allowing a surcharge, what it's really doing is allowing us to disclose the amount of that fee, allowing that business to engage in some type of speech saying this card costs that much. And businesses don't have many free speech protections under our Constitution, First Amendment, but the judge did find that this was one of them. And to the extent it is one of them, I want to get to Representative's question: will it increase our price? Theoretically, the price of that credit card is already baked into the price, what that product already was. We just couldn't show the amount of that fee. So you have to assume that no, it won't increase the price of what the product is, but it would allow us to disclose it. And that's a very important difference that I think the court rightly decided in Kansas, and the Supreme Courts have rightly decided over time. Currently, I think the entire act is unenforceable. Talked to Derek Schmidt last year about it, and he agreed with me on that. So I think the bill needs to move forward, and kind of under the pretense that it's unenforceable. There will be an amendment that we've talked with Mr. Stafford about, and I want to oppose this amendment because what it does is really what the underlying statute did. It puts the state as the defendant, and it basically hires the attorney general to defend their contract. We enter into a contract to swipe a credit card, and I don't want to bash credit cards. They have a useful purpose. They increase the speed of our transactions. They lower our bad debt. There's meaningful things that they do. But what I don't want to do is in statute allow them to hire the attorney general to basically to defend a business to business arm's length contract that we have to enter into. So I would encourage the committee to just strike the statute as the courts have done, and we'll stand for any questions you have.
Questions from the committee? Representative Schiff.
Thank you, Mr. Chair. Thank you for your testimony. You said theoretically that companies are already baking the fee into their prices. Is there anything in this bill that prevents companies from essentially just adding a surcharge line and then thus effectively charging twice for the fee, just to make more profit?
So a company can already add different fees. They can, you're seeing delivery fees added to their bill. Whatever cost a company has, it is basically a free market, and you would expect competition within that space to work against a higher cost product. That if there's two out there, and candidate X is charging me $2 and company Y is charging me $1, the marketplace is going to move toward the lower cost product. So I think built into this is everything is open. We wouldn't section out the price of hamburger, but price of flour, the price of bread. But this one at least allows us to disclose what that price is that we put into that product.
Representative Lewis.
Thank you, Mr. Chairman. You mentioned an amendment that you oppose. Could you be more specific on what that amendment is?
So within the very large contract that you have to sign with the credit card company, it's essentially a take it or leave it contract. So it's an adhesion contract. But if you want to offer their card, you have to engage in this contract. And I put some Q&A in my testimony, and the Q&A comes straight from the Visa website. So if you're curious of what you can and can't do with regard to disclosing a surcharge, that one of the requirements is, just like had a hamburger over at the Shack the other day, on their front door, they say, we will be charging a 3.9% surcharge on X date. So that's a notice requirement that they're complying with, and appropriately complying with, by the way, and it has to be on the receipt. So that's the Visa requirement. Every company is going to have different requirements. We think that ought to just stay in the business to business contract and not be in state law, because what will happen is the same thing that happened here. Derek Schmidt will be the one defending American Express. Why do they get to hire Derek Schmidt and I don't? I would say let's leave this business agreement on a level playing field.
So do I understand that the amendment that you're opposing would require statutorily the notice to be given?
Correct.
Okay, thank you.
All righty, seeing no further questions. Thank you, Scott. Thank you. Up next, we have Dan Murray, Kansas State Director, National Federation of Independent Businesses. Dan, welcome to the committee, sir.
Thank you, Mr. Chair. Members of the committee, Dan Murray, Kansas State Director for NFIB. Excuse me. Here today on behalf of our approximately 4,000 small business owners. You've heard all the reasonings behind this, but this is an extremely important bill for our small business retailers. I do want to point out to Representative Dodson's question earlier. Sorry, Scott, for being shorter than me. That there are specific exemptions written into the law for local units of government, higher education units. We think that's patently unfair for small business retailers, and certainly something that you all should maybe take a look at and consider when you take up this legislation. We are one of 4 states that currently still prohibit this. We would like to see some parity with those other 4 states. So with that, I'll shut up and take questions.
Any questions for Mr. Murray? Seeing none, thank you so much, sir.
Thank you very much.
Is there anybody else from the public that would like to speak on this? Seeing none, we will move to the neutrals. Actually, I'm sorry. We do have 3 written proponents: Jay Hall, Deputy Director and General Counsel for Kansas Association of Counties; Randy Stuckey, the Senior VP of Government Affairs, Kansas Grain and Feed Association, as well as the Kansas Ag Retailers Association; and Kevin White, Senior VP of Public Policy, the Overland Park Chamber. And now we will move on to neutrals. We have Amon Siddiqui, Director of State and Local Government Affairs for American Express. I apologize if I butchered that name, sir, but welcome to the committee.
Thank you, Mr. Chairman. Just want to make sure you can hear me, sir.
Yes, sir.
All right, thank you. Thank you, Mr. Chairman. My name is Ayman Siddiqui. You did a great job. I'm the Director of State Government Relations at American Express, and we appreciate the opportunity to comment on HB 2133 today. So, as we've heard already, Kansas had previously enacted a surcharge ban in 1986 to protect consumers, and recent court cases have declared that ban unconstitutional. So, we support the legislature's careful re-examination of surcharging following that court decision. But as with the original ban law, we feel that one of the things we should prioritize is the protecting of the consumers. HB 2133, as currently drafted, repeal the surcharge ban, but not provide any guardrails around unregulated surcharging. So American Express respectfully recommends 2 consumer protections to HB 2133. First, considering a reasonable cap to cap the surcharge amount, and the other, a robust disclosure requirement. So surcharging exposes individual consumers to added costs on transactions, from routine gasoline purchases to more costly expenses such as a car repair, medical care, child care, or even housing. It also impacts businesses and government entities that rely on credit cards for business expenses, like which surcharging can then be impactful to the bottom line. One of the things we want to keep in mind is that all forms of payment carry an operating expense to the seller. Cash, for example, can be costly to handle, inconvenient to process, carries risk of counterfeiting, theft, and credit cards solve these problems while providing additional value to merchants who choose to elect them. But by repealing the ban on credit card surcharges without placing a cap on the surcharge percentage, this bill would allow merchants to single out Kansas credit card users as the only customers to pay the merchant's full operating expense versus debit card users or people paying with cash. So we would recommend amending HB 2133 to limit the surcharge percentage in a way that would allow the merchants to recoup their average cost of accepting credit card payments over and above the cost of accepting other forms of payments. This would protect credit card consumers and make sure that merchants are able to recoup the cost of that credit card surcharge. And also, we would recommend including clear and conspicuous advance notice to the consumer of credit cards. This is something also that the Kansas House did pass last year. So the bill that y'all passed last year included that advanced disclosure. So we would like to include that same disclosure that y'all were able to pass last session. And so we appreciate the opportunity to comment and open to any questions. Thank you.
Questions from the committee? Oh, I'm sorry, Representative Mon.
Thank you, Mr. Chairman. Sir, I was just wondering what cap would you have in mind or suggested, and how would that work? Would it be a percentage cap or a dollar amount?
Yeah, I think we would recommend a percentage cap of about 2%. And the thing to remember is that there is a cost to debit cards as well. And so signature debit is the second most expensive form of payment after credit cards. And you're not allowed to surcharge on signature debit. So when the customer is paying with that form, that entire cost is included as a part of that transaction. So if you're going to single out a credit card customer, we would say that the 2% would be that the differential between the cost of signature debit and the cost of credit cards, which would help recoup the cost of credit cards to a merchant.
Any further questions? Seeing none, Mr. Siddiqui, thank you so much, sir.
Thank you, Mr. Chairman, members.
I have one written only neutral. It's Brock Roller with the General Counsel for Kansas Office of State Banking Commissioner. Is there anybody else that would like to speak neutrally on this bill? Seeing none, I have no opponents listed. Is there anybody that would like to speak in opposition? Seeing none, we'll go ahead and close the hearing on HB 2133. Committee, that's all we have for today. We meet again Wednesday where we will have a informational presentation on ESG. So I look forward to a lively debate on that issue. Thank you. We'll see everybody Wednesday. We are adjourned.